Number 48, Mulacek versus ExxonMobile Corporation.
Good afternoon, Your Honors. May I reserve 4 minutes for rebuttal, please?
Yes.
Thank you. May it please the Court. So this case is essentially an earn-out case. It's a case where Exxon, in acquiring an oil and gas exploration company called Interoil Corporation, promised IOC shareholders cash up front and then a second payment that was contingent upon a certified estimate of natural gas resources in Papua New Guinea. However, as we allege in our complaint, and as you can see from the agreements that were attached to that complaint, the determination of those natural gas resources was very complicated, and they were subject to manipulation by Exxon, and that Exxon had every incentive to manipulate those estimates downwards so that they could pay IOC holders less. In order to protect against that manipulation, the key agreement in this appeal, which is the Contingent Resource Payment Agreement, or the CRPA, placed express good faith obligations on Exxon to ensure that the determination of these natural gas resources was done in a fair and accurate manner. And it's a breach of those obligations.
I guess I read it differently, but correct me. I thought that the way they protected that was to send it to an outside independent agency to make the determination.
So the way that appraisals are done out in the field, Your Honor, is that basically you hire these independent appraisers. That's true. The appraisers...
But that's what the contract says, right?
That's what the contract says, but the appraisers never go out in the field. All of the data that the appraisers get...
Wait, so now is that in the record somewhere?
That's in the total sale agreement. And in the total sale agreement, it actually provides that all of the parties to the TSA, which includes the Exxon sub, that's would be part of the TSA, basically says that the Exxon sub is required to provide all reasonable and necessary data for the appraisers to do their duty. And under our complaint, what we allege is that Exxon didn't do that. They didn't provide all of that reasonable and necessary and useful data for the appraisers to actually come to the right conclusion.
And the question, I guess, is whether you can bring that or you need to have either the holder committee or the required holders.
Yes, the question on this appeal is Section 8.05, which everybody is calling a no-action clause. And under Section 8.05, the language in the second to last sentence is, only the required holders or the holder committee with required holder approval will have the right on behalf of all holders to institute any action or proceeding at law or equity, right? And what we say, the only thing that the plain meaning of these terms can mean is that if you want to bring an action on behalf of all the holders under this agreement, then you have to get 25% of the holders of these EVRs to approve it, to agree. You have to meet a threshold requirement to bring a class action.
Well, why can't you read it to say, if you have 25%, that 25% must bring the action on behalf of all holders, not just themselves?
The reason why you can't read it to say that would be, I think, it would basically effectively bar all actions, and it would basically make the contract...
You just have to get 25%.
Well, you'd have to get 25%, but then you'd have
Isn't that kind of a common device in lots of sort of commercial agreements, that individuals are not allowed to bring actions that either a trustee can, or in many cases, there's some threshold number of holders where if you hit that threshold, they can bring an action. But what you don't want them to be able to do is bring an action just for themselves. Is that fair? I mean, they're not a fiduciary like a trustee because they're just 25% of the holders. You don't want them to advantage themselves. Is that common?
It's common in indentures, Your Honor, which we would say are different. In indentures, right, you have a trustee. They're set up to basically protect the interests of the holders. And an indenture, basically, what you're trying to do...
And here you have a holder committee, which is kind of like the trustee.
Actually, the holder committee is not like a trustee. If you look at Section 5.04 of the CRPA, it says no holder committee member owes any duty of care or will otherwise be liable to the holders in respect of the performance of their duties.
Well, then that even better explains why on behalf of all holders is there and applies to both the holder committee and the 25% fraction.
Well, no, the holder committee can only act with required holder approval, right? So
Right.
you have to meet that 25%.
Right.
And the holder committee has no fiduciary or any other obligations to the holders. So the
Yep,
difference
except-
between this agreement and all of the other agreements that, this court has ruled upon that involve indentures, a lot of RMBS indenture decisions too, right, is the fact that there is an entire process. There is a trustee that's appointed to protect the rights of the holders. You have to give notice to the trustee. You have to provide indemnity to the trustee. And then if the trustee decides to act, then great, trustee's going to bring this action on behalf of all the holders. If the trustee decides not to act, then you're free to bring an action, right? I mean, that's how it works. None of those protections are here. And if you look at the CRP agreement
Yes, but
vis-à-vis.
I guess what I'm asking is, because none of those protections are here, doesn't that lean you towards reading on behalf of the holders to provide that same kind of protection?
It's on behalf of all holders,
Right.
Your Honor, and I don't think it
Right.
provides the same protection, because if you actually, and, this court has held repeatedly, including a decision that was issued last year, that you can look at similar contracts to ascertain the meaning of the contracts. If you look at similar contracts, and Exxon has admitted that CVR agreements, contingent value rights agreements, which again are premised on contingent payments sometime in the future based on milestones of performance, right, are similar to the CRPA here. If you look at the similar CVR agreements, which we cite, and we provide citations to where you can find those in the reply brief for 3 different companies, you see that there's almost identical language in those CVR agreements as in Section 8.05 and in Section 8.04, which Section 8.04 gives individual holders the right to enforce, right? The difference is that in those agreements, there is another section, and it's called Section 4.2, and in Section 4.2, a special committee is appointed, and it is given, and I'm reading from one of these agreements, a special committee has the sole power and authority to act on behalf of the holders in enforcing any of their rights thereunder. Exxon omitted that. Exxon is the one that drafted the CRPA agreement. So in omitting that particular section where the special committee basically has the right to enforce an individual's holders' rights to enforce the agreement, Exxon was basically saying, okay, well, that omission means something. Under quadrant, that omission means something. Exxon was basically saying, okay, well, individual holders have the right to sue. Because if individual holders did not have the right to sue, Section 6.02 would essentially be unenforceable, because unlike the indentures and RMBS and all of those things, this is not something that happens over a long period of time. We're not establishing a relationship between investors and a trust or investors and a company. This is where you're terminating shareholder rights, and you're doing that based on certain payments that are made. And you want to make sure that that contingent payment is done in a way that's fair and reasonable to the holders, right? So in those other situations, right, you have all of these protections for the holders. Here, you also have those protections, but it's apples to oranges when you're comparing an indenture to basically this agreement or CVR agreements.
I want to make sure I'm clear. When you referred to clauses in other agreements, right, you're not suggesting, but tell me if I'm misunderstanding you, that there are other agreements that have the same language we see here. I thought you had indicated that this language here was unique. Am I misunderstanding you?
This language here is unique if you compare them to any language that's found in no action clauses and decisions from this court or in New York State courts. This language is unique and different from what you find in indentures, which is really what a lot of the no action clause decisions are about. This language is not unique if you compare it to CVR agreements, which Exxon has submitted are similar to the CRPA. That's cited in our reply brief. I don't know the exact footnote, but I can provide it to you on rebuttal. But it actually lists out the CVR agreements. And it provides 3 examples with citations to where your honors could find them. And in those CVR agreements, the language that's found in Section 8.05 and 8.04 is almost identical.
But so that ends up being really a question of fact, right?
Yes. But at the same time, if in quadrant and in IKB, this court has held that you can look at similar contracts and see what the parties decided to omit.
Correct,
in
and that
deciding
goes to
it's-
that goes to understanding what their intent was and how to interpret the contract.
Yes.
Fair, and that's a factual issue for a trier of fact.
In Quadrant, this court decided that as a matter of law, right? In Quadrant, the court looked at similar RMBS contracts. In Quadrant, the question was, well, can you bring this action on behalf, can you bring an action for securities or any other common law things that are not covered by the indenture under this no action clause? Because the no action clause only said, under the indenture, essentially, right? And what this court said is like, well, let's look at what other RMBS contracts do, or what other indentures do. And then comparing other indentures, including a couple indentures from Delaware Chancery Court decisions, you said, well, in these other indentures, it says the indenture or the securities, and says, okay, in those situations, those bar all actions that are brought on behalf of holders unless the holders go through this trustee process. And so your honors actually decided that as a matter of law. In IKB was the RMBS case, and in IKB, your honors also decided that as a matter of law. And that had to do basically with whether or not a trustee should be on the hook for the repurchase obligation. And because there was no specific language that basically said the parties have the repurchase obligation, it was very vague. But your honor looked, this court looked at different RMBS contracts where the trustee is expressly listed as somebody who has the repurchase obligation. And by making that comparison, this court held, well, obviously you know how to do it. If you want to have the trustee have a repurchase obligation, you can put that in there. Similarly, Exxon knows how to use the word required holders, right? I mean, they put that in section 8.05, but they didn't put it in section 8.04, which gives individual holders the right to sue. They didn't put it in section 3.05D, which carves out breaches of Exxon's obligations under section 6.02 as something that holders can dispute. It doesn't say required holders, it says holders, right?
It carves it out of the proviso there.
Yeah,
Right.
it carves out a proviso from the
The
ADR.
carve-out is of the proviso, I think. No, you don't agree with that?
No, the carve-out is not of the proviso. So the proviso basically, because if the carve-out was of the proviso, it would basically mean that the
Because it
holders.
says, it being understood that this proviso shall not prevent, and then it goes on. So it's a restriction of the proviso, not a restriction as of the whole agreement.
Right, but I'm just saying that as an example, right? It carves out, it says, shall not prevent or restrict the holders
Yeah,
from.
this proviso shall not, right?
Yes,
Okay.
that this proviso shall not. Yes. Thank you, Your Honors, my time is up.
You have some rebuttal.
Good afternoon, Your Honors. May it please the Court, Andrew Ditchfield on behalf of the respondents.
Does this involve a straightforward no action clause?
Well, Your Honor, I think it involves a straightforward contractual provision, which we've shorthanded as a no-action clause, embracing the idea that the intent of that provision, Section 8.05, fitting in the broader context of the contingent rights payment agreement more generally, was to limit the ability or limit the exposure of the parties to the agreement, which were a rights agent and ExxonMobile entities.
But is the language used in 805 specifically, including the sentence with the on behalf of all holders, is that something that appears in other agreements or is conventionally used?
So I think the answer is yes, recognizing that there's no talismanic formulation that, or words that need to be used. And I had thought, coming in here, that the appellant's argument in the reply brief, which is at page 13 to 14, in referencing CVR agreements, which from our perspective are the most similar types of agreements, had language that we would describe, that they would describe as effective no-action clauses that would prohibit individual actions like the one that appellants brought here. And this is at page 13 and 14 of their brief. And then they cite at footnote 6 several CVR agreements, including one from Unum Therapeutics. And I took a look at Unum Therapeutics and just wanted to read a couple of the provisions, Your Honor. Section 4.2b says that the special committee shall not owe fiduciary duties to the holders and shall not have any liability to the holders for any actions taken. That's very similar to Section 5.04 of the CRP agreement that you heard about. And then Section 4.2c says that the special committee, notwithstanding the fact that the holders are the intended third-party beneficiaries of that CVR agreement, like in the case here, notwithstanding that, and that the holders have the ability to specifically enforce the terms of the CVR agreement, that the special committee has the sole power and authority to act on behalf of the holders in enforcing their rights hereunder. The language of Section 8.05 of the CRP agreement says essentially the same thing, just in a different order. What it says in Section 8.04 is that the holders, amongst others, have the ability to enforce the agreement. Section 8.05 starts from the premise that the only rights that the holders have under the CRP agreement are those expressly granted to them. Because remember, this is a contract that they are not parties to, they're third-party beneficiaries. And then it says, notwithstanding anything to the contrary in the entire agreement, only, right, solely, the required holders or the holder committee with the required holder approval will have the right on behalf of all holders.
Let me stop you there if I can. What meaning do the words "on behalf of all holders" have under your understanding of the contract?
Your Honor, the way that we read the contract is that on behalf of all holders means that the right that is invested in either the required holders or the holder committee is a right to initiate actions, and they hold that right, those two bodies hold that right on behalf of all holders. And so I think if you look at Section 5.02 of the agreement.
Specifically, though, why would the meaning be different if those words were not there as opposed to them being present in the sentence?
Well, I think what those words do is clarify the purpose of this agreement and the bodies, the required holders, or the holder committee that are authorized to act.
I'm just trying to understand if it's surplusage under your reading.
I don't think it's surplusage. I think what it's doing is it's clarifying that even though the holder committee, I'm just going to use holder committee because it's easier to say, holder committee has the right to initiate an action, it holds that right on behalf of all of the holders under the agreement who are the beneficiaries of the agreement. And I think that language, that clarifying language, is then standing in contrast to the language at the end of that sentence, which says that no individual holder or other group of holders will be entitled to exercise
What
such.
independent meaning does that last clause have under your reading that's not surplusage?
You mean the no individual holder language, Your Honor?
Yeah.
Well, keep in mind here that the purpose of these agreements, under this court's reasoning in the Quadrant case, is to limit the exposure of the parties to this agreement. And
So is your view that it's belt and suspenders or clarifying or something like that?
Yes, I think what this language is making absolutely clear, right? Given the broader context, right, which is the holders are third-party beneficiaries. Under Section 8.04, they have the right to enforce the agreement, but they can only act to enforce those rights if they get 25% or more of the holders to act together, either as the required holders or through the holder committee, which requires required holder approval. And so what this language is doing, and this is what Justice Ostrager understood, and this is what the majority of the First Department understood, is it's making this provision, Section 8.05, clear as day that there is a right to sue here. There's a right to initiate any action or proceeding at law or in equity. That language, the holder committee or the required holders have broad rights to initiate any action, so long as it's arising under the agreement. And there's no dispute that the appellant's claim arises under the agreement. And then that remaining language says no individual holder, even though the holders are the beneficiaries and they have the right to enforce.
So what meaning then do you assign, if you look at 804, which I realize governs successors and assigns, but the first sentence says this agreement will be binding upon and will be enforceable by, et cetera, the holders, and then it goes on and lists other categories. So does that, what do we make of the fact that 804 says that the agreement is enforceable by holders and not required holders or the holders committee only?
I think what this is saying, Your Honor, is that when you look at what the agreement grants, which is a right to a contingent payment on the part of the holders, right, that this is saying that they're express third-party beneficiaries. They have the ability to enforce this agreement, just like in the Unum Therapeutics CVR, provision 4.2c says the holders shall be intended third-party beneficiaries and shall be entitled to specifically enforce the terms hereof, provided that only the special committee under the CVR can act to.
So how would they enforce it otherwise?
Well, the holders, consistent with the purpose of the CRP agreement, which is to minimize the exposure to individual strike suits, the holders would have to amass enough support in order to comprise the required holders, right? And I think that the language as a whole, right, both the language that the parties use, that the contract uses, is very clear, and that the purpose of the statute is consistent, the contract is consistent with the reading that Justice Ostrager applied, that the First Department majority applied.
Well, why isn't the dissent correct, that there's an ambiguity because of the failure to include the standard no action language?
For two reasons, Your Honor. One is, I don't think that there is standard language in a contingent resource payment agreement, for no other reason than that I'm not aware of any other contingent resource payment agreement. And that's why we analogized to the contingent value right agreement. But secondly, I think that the majority was correct in saying that what's necessary, what's important, is does the language that's used make clear what the parties intended? And you don't need to use any talismanic words. You don't need to have a particular formatting. You just need to make clear what the parties intended.
And you think that's done?
I think that's absolutely done, Your Honor, because I think if you look at this language and you take a look at, say, Section 5.02 of the CRP agreement, which says that any time the holder committee brings a lawsuit, any lawsuit, it does so, it has to do it in its own name. So it's not a class action per se. It's not acting, individually and on behalf of all similarly situated. And it does so, if it gets a recovery, it has to distribute that recovery pro rata to all of the holders. It is literally acting on behalf of all of the holders as it acts as the holder committee authorized by at least 25% of the overall holders. And so not only when you look at the language of Section 8.05 standing alone, but you look at that provision in the context of the agreement as a whole, and you look at the agreement in the context of the commercial arrangement that was struck here, all of those support the reading that the First Department majority applied and not the reading that the dissent advocated, which was, in their view, at least there was an ambiguity. And I submit, Your Honors, that reading this contract within that broader commercial arrangement, to the extent that there's any ambiguity, and I don't believe that there is, eliminates any other reading, because the whole idea here, if you take a step back and you look at this transaction, this was a 2017 transaction. It was the second iteration of a transaction that one of the appellants successfully objected to in front of a Canadian court proceeding in 2016. That transaction, which included both a fixed component of deal consideration, $45 per share in Exxon stock, plus a contingent right payment, if the estimates through these independent appraisers that you heard about from my friend Ms. Kim came above a certain measurement, 6.2 trillion cubic feet equivalent of natural gas underground, right? And this gas is being tested by appraisal wells. So you have the February 2017 agreement signed up. It was subject to Canadian court approval. The appellants and all other holders have the ability to forego the right to obtain a contingent right payment and pursue dissenters or appraisal proceeding in the Yukon courts in Canada. And some holders did, and they lost. The Canadian court concluded, the Canadian Court of Appeal, the Yukon Court of Appeal concluded that the $45 per share plus the payment that was made under the CRP agreement to holders was fair and reasonable. It reflected the fair value of InterOil. And so what appellants did, let me take a step back. Under the CRP agreement, ExxonMobil funded an escrow account, and then it took that money out as a loan per the terms of the escrow agreement, the CRP agreement, and then it was responsible, once the independent appraisers made their determination under the Total sale agreement of the estimate in the fields in Papua New Guinea. That led to a calculation of the contingent right payment. That payment was then made. Under Section 3.05D, the holders had the opportunity to dispute that payment, right? And if they did, they had to deliver a dispute notice. But if they didn't deliver that dispute notice within 30 days, then ExxonMobil's obligations under the CRP agreement were concluded. The whole idea here was to put in place a structure that got holders the compensation that they were entitled to under the InterOil ExxonMobil merger agreement, and then ExxonMobil moved on. What that wasn't intended to do was allow individual suits under the CRP agreement 4 years later, like the appellants have brought, which is exactly what Section 8.05 was intended to curtail. Unless your honors have any questions, I very much appreciate your time.
Thank you. Counsel, could I ask you to start with Section 305D?
Yes, Your Honor. Section 305D, Your Honor, is not, as counsel contends, a section where you can dispute the payment, the contingent resource payment. What you can dispute is basically the math. And it's very clear that under Section 3.05D,
By the math, you mean the calculation of the reserves?
Yes, not the calculation, no, not the calculation of the reserves. There's actually like specific formulas throughout the CRP agreement that basically says, okay, well, once the calculation of the reserves come in, you take that, you multiply it by X, you divide it by Y, you take it to the 13th power, and then this is the actual payment that you get. That's the math. So basically, if you look at Section 3.05D, it says expressly, if the required holders dispute either the calculation of the distributable CRP payment or loan proceeds payment set forth in the achievement certificate, the achievement certificate means that there was more natural gas than 6.2 TCFE found in the natural gas fields in Papua New Guinea, or acquisition companies, that's Exxon's, assertion in the non-achievement certificate that the payment condition has not been certified, which basically means we didn't find more than 6.2 TCFE in the natural gas fields in Papua New Guinea, then you can basically put forward a dispute notice. That's it. That's all you can do under Section 3.05D. It makes sense because I went through the math, and math wasn't my best topic, which is why I'm a lawyer. But I went through the math. It is a lot of really complicated calculations to figure out what the loan proceeds payment is and what the CRP payment is. And so if you get the CRP payment and you say, wait a minute, I did the math, I took what the estimate of the reserves were, I applied the formula that's in the CRP agreement, and it turns out that you guys, basically missed a decimal point. right? Then you can basically dispute the matter, and then you set forth, and it says here how you're supposed to do it. You're supposed to set forth the proper calculation of the distributable CRP payment. You can't put forth the proper calculation of the CRP payment if it has to do with the amount of reserves in the natural gas fields. Nobody knows that except for the people who are out in the fields and the people who are appraising based on good data that's provided to them from these appraisal wells. I do want to address a couple of things that counsel read to your honor from the UNAM CVR agreement. You know, he claims that section 8.05 deals with everything that's in 4.2, but that's not true. If you look at section 7,
Are those in the record, counsel, or no?
they're cited in
Yeah,
our,
I saw the sites, but, okay, thanks.
yeah, they're cited in our reply brief, your honor, at the pages I believe counsel provided to you. But in section 7.5 of the CVR agreement, it's the language identical almost to 8.4. It says, "The agreement will be binding upon and will be enforceable by and inure solely to the benefit of the holders," et cetera, et cetera. And then section 7.6 has almost the identical language as section 8.05. "Except for the rights of the rights agent set forth herein, the acting holders will have the sole right on behalf of all holders by virtue of or under any provision of this agreement to institute any action at proceeding at law or in equity." It's clear they use the CVR agreements as a model, right? What they didn't include was section 4.2C, which specifically it restricts an individual holder's right to enforce the CRP agreement. It says a special committee has the sole power and authority to act on behalf of the holders in enforcing any of their rights hereunder. Exxon omitted that from the CRP.
Why is that different from a no individual holder or other group of holders will be entitled to exercise such rights?
Because if you look at the text of section 4.2C, it says a special committee has the sole power and authority to act on behalf of the holders in enforcing any of their rights hereunder. And holders is defined as a person who holds the security. It's the same definition in the CRPA, right? A holder is a person who holds an EVR. If you read section 8.05, it says on behalf of all holders, right? If you're going to read the CVR agreement that we cited consistently, it means for individual holders who want to bring a lawsuit, they have to go through the special committee. If you want to bring a class action on behalf of all holders, you have to meet the threshold requirement, which in UNAM, very coincidentally, was also 25% of the holders. So it's, in order to read all the provisions in the contract as a whole, as counsel suggests, you have to read them all together, because otherwise, it would basically mean that the provisions would conflict, right? You'd say, well, the special committee has the right to enforce on behalf of all holders, and the acting holders have the right to enforce a right on behalf of all holders. What is it? Well, they used very specific language here. In section 4.2C, it says the holders, right? The special committee has the right on behalf of the holders, individual holders. And in section 8.05, it says on behalf of all the holders. There's
Does
only
on
one.
behalf of all holders contemplate a class action as opposed to some more sort of representative action?
It would have to be a class action, Your Honor, because, I mean, there's no entity, because I know counsel keeps referring to the holder committee, but the holder committee is basically the former CEO of IOC and the chairman of the board of IOC. They were trying to push this deal through, right? So it's basically the required holders under that provision. And the required holders have no fiduciary obligations to the holders. How could they, right? It's an
They could
unidentified.
have a contractual right without a fiduciary obligation, no?
Yes, but again, they don't even have any contractual obligations to the holders, because the required holders, they're not,
No,
it's not a
Not a
trustee.
contractual obligation of the holders, a contractual right to sue on behalf of the holders.
Right, but the required holders, again, is not one person or one entity.
Right.
It's just 25% of unidentified holders. So in this situation, and this is again why it's different from indentures, the EVRs are non-transferable, right? So what you have is what you get. So let's say you have a required holder who holds 30% of the EVRs, would have to be an institutional investor, and they say, well, I want to bring an action. And then Exxon says, well, that means you have to bring an action on behalf of all holders. And the required holder says, wait a minute, that's crazy, because that means that I have these fiduciary obligations that are established under class action procedure, and this contract doesn't even provide me with indemnity. Indemnity is something that is always provided in those other no-action clauses in the indentures, right? And it's in order to protect the trustee for all the actions that it takes on behalf of all of the holders. That's not even provided. No institutional investor, no required holder would want to take on that liability without getting some sort of indemnification. That's not provided here. So the only reasonable interpretation is that Section 8.05 sets a threshold requirement if you want to bring a class action. Makes sense. There were 51 million EVRs that were issued. That would have made the case against Exxon over $1 billion. Exxon wanted to prevent that. At the same time, there is no way that this agreement would have passed muster with the Yukon courts for fair and reasonableness if Section 6.02 was not enforceable.
Thank you.
Thank you.